Hear me, sir?
Thank you.
Can you hear me?
Yes.
Okay, fantastic. You're welcome. Go ahead, counsel.
Thank you, Your Honor. Ours is a simple non-residential eviction case. Mr. Lonsway, the defendant in possession, Mr. Talaski, the defendant in possession, has been leasing the fields at the property 10 years for horses.
The tension kicks in immediately with this case, and the stakes aren't small. We're about to watch a battle over property rights, liability, and a man's future with his horses. On one side, you've got the property owner's attorney laying out a textbook property law principle. A landowner can evict someone even without giving a reason, as long as the notice is proper. That's the hammer of property law. On the other side, you have a defendant who has lived with and cared for horses for decades, now being told to uproot everything. Think about the imbalance here: contracts, fences, liability, and cold hard law, versus years of personal sweat, relationships, and animals. This isn't just numbers on a page, it's a way of life colliding with legal reality. Stick with this case, because it's going to twist between sympathy and hard facts, and the judge has no patience for dodging the bottom line.
He's received the notice to quit, which was sent to him December 6th, 2023, informing him to remove his horses and vacate the property by February 1st, and he has not done so. It is a fundamental principle of property law that a fee simple property owner has the right to exclude anyone from their property for any reason or no reason at all. We're not obliged to justify to the defendant or this court the reason for the eviction, but in the interest of fairness.
Notice how quickly the attorney cuts through emotion. He makes it clear under law the owner doesn't even owe an explanation. That one line sets the tone. This isn't about compassion or history, it's about strict property rights. But then, almost strategically, he does give reasons: liability, broken fences, roaming horses. Why? Because courts and judges like to hear fairness even when the law doesn't demand it. He frames the case not as personal animosity, but as practical necessity. Clever move. If the horses had already escaped into the road, we'd be talking about lawsuits, injuries, or even worse. The lawyer is preempting sympathy for the defendant by reminding everyone that safety and financial burden are real issues. Ask yourself, is this strategy overkill, or is it necessary to keep the judge focused on cold facts instead of emotional appeals?
And to put it on the record,
You're going
I'd like to do that.
You're going to give me a lecture on doing for 35 years?
Well, no, I know, sir. You're quite qualified. I know that. This is simply, it has nothing to do with animosity. It's purely a question of liability. Maintaining this property for the keeping of horses has become prohibitively expensive. The fences around the property are rotting and fallen down. Whole sections of the fence are being held up by steel posts wired to the rotting fences. My client intends to just tear down the fences because of their disrepair. The defendant's horses got out on 3 occasions last year, and luckily they stayed on the property, but we fear they will wander into the road or worse. There are other annoyances, but they pale by comparison to the liability and the fence repair cost issues, which my client simply cannot keep up with. The defendant needs to get out immediately and hopefully pay my client for the months that he has overstayed. This is not an eviction for failure to pay, although he has failed to pay. Either way, we need as soon as possible. Thank you.
Okay, it's far hard for me to hear him. I'd like to see what he said, but anyway, go ahead. My turn?
Yes.
Okay. I've been doing horses for 50 years in this area. Whitmore Lake, Livingston County, Oakland County.
Here's the emotional counterpunch. The defendant leans on experience, legacy, and community roots. He paints himself as a lifelong horseman, a fixture in the region. This isn't just any tenant. He's trying to show he's earned trust over decades. And then comes the fire story. A barn burned down, allegedly from the owner's negligence with a chicken coop and heat lamp. That detail matters. It shifts blame and builds sympathy. But legally, it's a distraction. The question isn't who burned the barn, but whether his lease allows him to stay. Still, juries, or in this case, judges, are human. They hear loss, resilience, and history. And those details stick. The defendant is trying to create moral weight to balance the legal scale. Do you think history and hardship should matter in eviction cases, or should the law stay blind to all that?
And I was at places 18 years. This place with Mr. Longway, was 12 years. And this all started in November of 2021, when they had a big cow barn. He has 3 pastures that I rented, and he had a big cow barn that it burned down. It burned down because Mr. Longway put a chicken coop inside the barn with a heat lamp, and I was called by neighbors that the barn was burning, and the police, the fire department were out there. It's a long driveway, and they were pumping water, and they finally put the fire out, and so everything of mine was destroyed. Everything that Mr. Landry had, tractors, canoes, he had the machinery, new roof, silos were out there, and he, it burned down, and that was not my fault. And Mr. Landry approached me and said, the horses can stay here, although they were now in one pasture. And so I accepted that, and I didn't demand him to do anything to me or reimburse me. And so
Sir, let me just ask you, is there a written agreement for the leasing of the land?
This is the exact pivot moment. The judge asks the only question that matters. Is there a written lease, and what does it say? Everything else, fires, barns, hardship, is noise, unless it ties back to contract terms. The defendant admits there was a lease signed in 2010, but already his timeline sounds shaky. First he says 2003, then 2010, then maybe 2013. That confusion undermines his credibility. Courts love clarity. If you can't pin down dates, you look unreliable, even if your story is true. And notice the judge's patience thinning. He wants facts, not wandering narratives. This is the core legal battleground, written agreement versus oral claims. And courts will almost always lean on paper. That's why lawyers preach. If it's not in writing, it didn't happen.
yeah, we signed an agreement 2010. Okay, we had a
For how long?
no, then I don't think it said anything. It was just started to protect Mr. Longway, because we had a kind of a disagreement with some people about cutting the hay in a hay field. And so he just said, well, we need a lease down there. How much was it? And eventually it went up $200 a month. And
Well, I guess what I'm trying to figure out is when did that lease expire?
didn't never expire. Never, there was no limit other than Mr. Longway filed for me to leave probably 2003.
Okay, but
Go ahead.
that would have been before the written agreement.
No,
Right.
that was after the agreement. Yeah.
So when was the written agreement?
Huh?
When was the written agreement? I heard you wrong, maybe.
2010, something like that.
All right, but you said he filed to have you leave in 2003? Or
No,
did you mean
no.
2013?
No, 2023.
23.
Yeah.
Okay, gotcha. Okay.
Well, the problem was, okay, just another thing. So about 6 months later, he was cleaning up, And he got the idea, the horses were getting out after the barn burned down. And we went and fixed the fences up. So they were confined. But 6 or 8 months later, he came up with that the horses were getting out and he was liable, which wasn't true. They never got out before. And he said I had to leave. And so then
Okay, so first of all, help me. How many horses are there?
there were 3 on one side, 1 on the other side.
So a total of 4.
Yeah.
Okay.
Right here, the judge simplifies the mess. How many horses are we even talking about? 4. Why does that matter? Because courts deal with specifics, not generalities. Liability for 1 horse is different from liability for 4. Feed costs, boarding options, transportation, everything scales with numbers. The defendant then reveals he doesn't even have another place ready to move them. That's huge. Judges want concrete plans. Eventually doesn't cut it. Sympathy only goes so far when animals, liability and deadlines are on the line. The defendant is trying to buy time by highlighting personal injuries and challenges, but the judge zeroes in on logistics. This shows how judges slice through emotion to get to enforceable facts. If you were in Judge Simpson's chair, would you trust eventually as a commitment, or would you demand a firm date on the spot?
And do you not have a place to put them?
No,
Is that the
well,
issue?
another problem happened.
Okay.
I got, so on 1 August of last year, I was bringing hay to the horses, or I went to buy hay. I couldn't buy the square bales.
What follows next is the part investigators still talk about, the moment where motive, method, and mindset collide.
So I looked for some round bales. I found 2 of them. And so I loaded them up and I brought them to one was a big one was a small one. I loaded the small one when I got to the farm into one paddock. And I went to unload the big one and I couldn't. It wouldn't move. And I tried everything that I could do, run up to the vehicle, run down and see if it would move. It maybe moved a little and sat back. So fine, and I didn't have any ropes, which I usually had because they were all burned up. And so I went up there one more time, tried to push it off, and I got my legs and caught in the hay, and they just, I was kept there I fell off the back of the pickup. My legs stayed in. I laid on the ground. There was nobody there. I started to call for help, but the driveway was 150 yards. So I laid there till 4 in the morning, from 4 o'clock until 4 in the morning. Then the daughter came and she heard me. I don't know if she was with somebody, but I tried to tell him to move the bale, but then I said, call 911. So I ended up in U of M hospital for 8 weeks because my leg was so swollen.
This is where tragedy collides with law. The defendant isn't making excuses. He's genuinely been through hardship, a severe injury, 8 weeks in the hospital, rehab and ongoing pain. You can feel the human weight here. But the judge's role isn't to measure sympathy, it's to enforce property rights and safety. Injuries don't erase legal obligations. At the same time, judges are human, and these details do influence how much time they might grant before enforcement. Think about the audience impact. Do we side with the law, which says move the horses, or with the man who physically can't? Cases like this show the brutal clash between compassion and contract. The law can't bend for everyone's story, or chaos would rule. but you can tell Judge Simpson is already calculating how far he can stretch fairness without breaking the law.
U of M and rehab. Finally, I got out in October, 1 October,
Okay, so what does this have to do with you being on the property?
because I had to do this with this leg, and it's still bad. It's still bad for me. And
Okay.
I need somebody to help me, feed the horses with these round bales, which gives me time to look for a place and to try to heal. I have an appointment. I had one appointment with VA, and she looked at me and said, well, let's wait till to April, and we'll look at it again. And I want to find out what's my prognosis, because I can't feed the horses the way I want to give me time. Otherwise, I'd have to be there every day. And I live in Monroe, and I have to drive 50 miles. So I'm looking for them for at least 30 days, but maybe 60 days, to see how I'm going to do, keep the horses there, pay my rent. And Mr. Lanchway said I could stay, and then he changed his mind based on error, if nothing else. Go ahead.
Okay, but what I'm hearing
Yes.
is that you'll move the horses,
What?
that you'll move the horses.
Eventually, yeah, I have to move the horses.
Well, eventually is probably the problem.
Well, right, yeah. Because I'm in Monroe now. I have been there only a couple of years. I haven't found a place. I had one place lined up. They changed their mind. So, go ahead.
So I get back to my question. How long do you think you need? I'm not
Well,
saying you'll get it, but how long do you need to get the horses?
Well, I have an idea on the 2nd of April, but I would need at least 30 days to stay and have somebody there that will help me. I know he will. And so I can look for some more. I'd
So-
rather have 60 days.
No, I know, but just so I'm clear what you're telling me,
Yes,
you're telling me that in 30 days, you could have the horses moved.
if everything goes right, yeah, I could probably do that. But I don't want to be alone at a new place without an assurance that my leg will help me do the chores that I need.
No,
This is the turning point. The defendant admits he can move the horses within 30 days if everything goes right. That single phrase is dangerous in court. Judges and lawyers hear uncertainty, and uncertainty means enforcement trouble later. The judge knows that relying on ifs leads to endless delays. Notice how Judge Simpson pins him down. So what I'm hearing is you're in agreement, it's just timing. That's a classic judicial strategy. Summarize and box the party into a yes. From here, the question isn't if the horses will move, but when. The sympathy factor is real, but the judge must avoid setting a precedent where health or hardship endlessly extend obligations. If you were the property owner, would 30 days sound fair, or would you be pushing harder for immediate possession?
I understand that,
Yes.
but the issue isn't that part of it. The issue is that the horses need to be moved.
Yes.
Okay, so what I'm hearing is you're in agreement to that. It's just
Oh, sure.
timing of the move.
Yes.
All right. Counsel, how soon is there any leeway you have regarding when the horses will move? Because I will just say this.
Yes, sir.
If it had to go to a judgment, you had to have the horses removed. And that means you're going to have to call somebody to move the horses, potentially board them. And that's an expense that your client will initially at least incur. So balancing that, is there any leeway in terms of time of the move of the horses?
The defendant's had far longer than the statutory notice. He was on notice of this 9 months ago.
The attorney is back with precision. He reminds the court that the defendant has already had 9 months' notice. That's not just a legal fact, it's a strategy. It shuts down arguments of surprise or unfairness. Courts give statutory deadlines, and here those deadlines have already stretched beyond reason. Yet the attorney still offers 30-60 days as a concession. Why? Because it makes his side look balanced, reasonable, even compassionate. Smart lawyering appear flexible while never conceding core rights. Judge Simpson now sees one side grounded in law and timelines, and the other side rooted in hardship and delay. Both arguments matter, but courts tilt toward enforceable timelines every time. This highlights the real drama of civil law, balancing rules with empathy. The tension now is clear. Does the court give him until the 30th of April or enforce something sooner?
We can accommodate 30 days. That's not unreasonable given Mr. Tuleski's situation, or somewhere thereabouts. 60 is probably a little bit too long. I wouldn't like to face my client and tell him that's how long it was, but 30 to 60 would be acceptable. Yes.
I'll pay on the 15th of the month. So I would like to, continue that 15th of the month, 60 days in advance. And that's the way I've been paying. And just to keep the math right, so whatever the date is, it should be the 15th of the month. So today is 15th of the month, but I think after 2 April and I see the VA, I'll have better idea and 15, so, but anyway, that's what I think would be fair. Go ahead.
Okay. If I gave you 30 days from today, and I can't, here's the problem. I feel for you regarding your leg,
Yeah.
but I can't condition the moving of the horses on that. Okay. I can't say, well, once you get better, then that's when it will happen.
Yeah.
I certainly can take that into consideration, but it seems to me that the issue here is that if you had them out by the week of the 15th, gave you that 15th of April, could you do that?
Again, I'd have to see what is available on the 2nd.
Okay,
And
but here's going to be the
what I would be doing,
sir, here's going to be the problem.
yes,
They're going to get a judgment for possession. The question is when will they be able to execute on that judgment to basically forcibly remove the horses from the premises? All right. If they do that, it's going to be a problem for everybody, quite frankly. Whenever we get into these cases, it's a problem all around.
yes.
Don't want to get to that point. So we're going to have to pick a date, and somehow or another, that date is going to have to be the date that happens, unless you guys come to some other thing, if something happens.
Yeah.
But that's going to be the date of the court's order.
Judge Simpson makes it plain the court is not in the business of maybe. There has to be a hard date, an enforceable deadline, or else the order means nothing. He warns both parties, if the deadline isn't met, the sheriff may get involved. That's a serious escalation. And notice the subtle pressure. That's going to be the date, unless you guys work something else out. Translation: the judge is pushing the parties to settle the timeline themselves, but if they can't, his gavel will decide. This is a masterclass in judicial authority, firm but measured. He doesn't want chaos with animal seizures, sheriff involvement, and humane societies, but he makes it clear that's where this could go. Question for you: Should judges have more discretion to bend deadlines in hardship cases, or would that open the door to endless abuse of the system?
Well, how about 30 April? 30 April. 30 April would be,
Council?
Well,
We
that,
can accept that provided there's some type of penalty if he doesn't have them out. We can just turn the horses out and what happens to them happens. My client is not in the position of being able to
well, you
of caring for his
can't do,
horses.
can't do that because if you can't just let him run. If it gets to that date,
just
he's got to,
Then what
I mean-
surety do we have, Your Honor, that he gets them out on the 30th? If you have a suggestion,
well,
I'd like to hear it.
the only surety that you have is you'd have to call the sheriff's department to execute on a writ. And then the reality of what happens in these situations is you call the Humane Society comes out, gets the horses. I don't know if they're still doing that, but that will the last time this was done, that takes time because the Humane Society doesn't board the horses themselves. So then they have to find individuals to take the horses, which won't happen overnight.
I'm learning far
If
more
you're
about this than I
asking,
ever wanted to know.
if you're asking for some guarantee, I can't give you a guarantee except a date where you can then exercise your legal remedies.
Correct.
That's the best that I can do.
okay, I still plan to pay rent. I have money in my pocket. And so, you know, he refused to take my money, so I'm willing to pay.
Okay, so how much are you behind? So that's, yeah.
Okay, 15 January, 15 February, that's 1 month. February to March is 2 months. I got that in my pocket.
So
So then,
you would be paid through March 15th. You're saying with what's in your pocket.
yes. That's today.
Okay, and how much is rent?
200 a month.
Okay, so you have 400
Yes,
that you can get to the plant.
I could give,
Okay, so now let me ask you this. When could you get the March 15th to April 15th payment made?
oh, anytime. I mean,
Okay,
I was
so,
gonna do it
so,
yesterday, but
okay, so
Yeah.
here's what we're gonna do. I'm gonna grant them a judgment for possession with the writ date being April 30th, 2024.
thank you.
You're to pay to the plaintiff the 400 plus an additional 300,
Yes,
which will then be half, I'm taking half of April.
yeah.
So you'll pay the 15 days in April.
that'd be fine.
All right.
I can write him a check. I can write him a check today.
Okay. I'll let you guys handle that because that's really not part of the case, but I'm going to order that be paid. Otherwise, I'll issue a writ sooner. Okay, so you paid through the 30th. You're going to be paying to the plaintiff a total of $700.
Here comes the math, and Judge Simpson handles it decisively. $700 total, covering back rent, current dues, and half a month forward. Why does this matter? Because it anchors the case in tangible numbers. Courts like clean math, X months, Y dollars, Z deadline. The defendant tries to show good faith by saying he has the money in his pocket. That's important. It signals willingness to comply financially, even if he's struggled physically. But the judge also signals that if payments don't land, the writ could be issued sooner. It's a carrot and stick approach. Comply with rent and deadlines, and you get a little leeway. Fail, and enforcement comes down fast. This shows how judges juggle fairness with structure. The human drama is real, but the law is being packaged into cold, enforceable numbers.
Which is really the
Right,
400
yeah.
that you have
Sure.
the next month and then the 15 days.
Well, I'll pay him when, okay, that's fine. Yes,
Okay?
Yeah.
And then a writ would issue on the 30th. Okay?
thank you.
All right.
Thank you, Your Honor.
I need a judgment. You're welcome.
You have one here that I can fill out?
I don't.
Not you.
Are we good to go?
But I think they might have some up front. at the front counter.
I have a
I'll sign.
blurb here. Would you like to have this?
What's the blurb?
Well, you know, what happened over over the years. I gave
You
him.
want me to read history?
Yeah, it's up to you.
I became a lawyer, so I don't have to do history or math.
Okay.
All right.
That's what I usually tell clients.
All right. And sir, you're a veteran?
Yes, sir.
What branch?
Retired Army.
Army?
Yeah,
Okay.
thank you.
My,
Are you?
thank you for your service. No, my dad was, in, but thank you for your service.
Thank you.
All right.
Support.
Because, I didn't have to serve because of people like you that did. And I'm always mindful of that.
Huh? Oh,
All right.
thank you.
All right.
Thanks.
That's right.
She wasn't trying to take you in. All right. Take care.
This case ends with a balance of compassion and law. Judge Simpson acknowledges the defendant's service, sympathizes with his struggles, but still enforces the eviction with a clear deadline, April 30th. The horses must be gone, and $700 must be paid. What we've seen is the collision of two worlds, the rigidity of property law and the humanity of a man who built his life around his animals. The ruling reminds us that courts don't just weigh facts, they weigh fairness within boundaries. For viewers, the big takeaway is this: verbal promises and history rarely protect you when contracts and property rights collide. Deadlines are firm and courts will enforce them, even against sympathetic defendants. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.